So my name is Ólafur Einarsson and I'm the Registrar of the court, and I will sort of continue or pick up where Melpo left it and discuss a bit the EFTA Court I have here. I will do this at a relatively brisk pace. If there's something you don't understand, you can ask questions, then we will take joint questions later on. I intend to discuss the legal framework of the court very briefly, some interesting cases, and sort of what I call the interpretation of EEA law and the relationship between the EFTA Court and the ECJ, which is really at the heart of this whole exercise, the EEA agreement. Before I go into the court, I will want to say just a few words about the nature of the agreement and what sort of beast it is. I have highlighted the keyword linking the agreement, which links the EFTA states and the EU via the EEA agreement. That's homogeneity. That's uniform rules applied and interpreted in a uniform manner. The same rules, meaning the same, should be the same. That's the key aspect of it, and that sort of is in this lingo called homogeneity. I don't know whether this morning you've gone into details on the nature of it, but I have the EEA agreement, and I will revert to that very briefly, is something between supranational EU law and public international law, and it's really it mixes both elements. There is no transfer of sovereignty, at least in the sense that legislative powers are not vested in the EEA institutions, although this is in itself quite a complicated issue. There is no supranational decision-making power except mainly in the field of competition, where Melpo has mentioned that ESA can fine undertakings, and indeed in Telenor fined the company the not inconsiderable sum of 112 million euros, which is quite something. Then, on final point on this intro is that the constitutional principles of direct effect and supremacy are not found to the same extent in EEA law as in EU law. This is important for context. Then the EFTA Court is, again, we both refer to Article 108 of the EEA agreement, which is the agreement which places the obligation on the EFTA states to establish a court of justice and a surveillance authority, which they discharged in the so-called surveillance and court agreement, the SCA. And there I quote on this slide, Article 27, which states that the EFTA Court is hereby established. The EFTA Court was not originally a part of this institutional setup. There was supposed to be an EEA court, and even an EEA court of first instance, composed of judges from the Court of Justice and judges from the EFTA states. And everything was signed, sealed and delivered. And on the 14th of December 1991, the Court of Justice said no, that this doesn't work. So there was a very frantic month of December and January 1991-1992, which resulted in the establishment of the EFTA Court. And this opinion 191 is a very interesting story, but given that I have about 20 minutes, I will resist the temptation to discuss that. Then also part of the SCA agreement is the statute of the court, which is sort of the framework, and then the court itself sets rules of procedure, and they recently underwent the first wholesale revision since 1994, and they have been adjusted to mirror the rules of the Court of Justice and to some extent the General Court of the EU, because the EFTA Court is more or less acting as the Court of Justice in the advisory opinion, but in the direct action for annulment, and I will explain this a little bit later, it sits as an administrative court more or less like the General Court. A final point on this is the jurisdiction of the EFTA Court. It is to rule on the interpretation, and I emphasize the word interpretation of the EEA agreement, and when I say the EEA agreement, that's the main part of the agreement and all the acts referred to in the annexes and the protocols, so which loosely could be called secondary legislation. if you think ESA is small, the EFTA Court is smaller still. It is about 20 people, and it's the same method as with the ESA College, that each EFTA states nominates one judge. The judge has a cabinet with legal secretaries and assistant, and the registry is responsible for procedural questions and the administration. We are about 20. The EFTA Court is, I think, the only international court sitting in a state which is not a contracting party to the convention establishing the court, but the court is in Luxembourg, and the reason it is in Luxembourg is, of course, that the Court of Justice is in Luxembourg. Interestingly, the court started its life in Geneva because Switzerland was supposed to be a member of the EEA. The Swiss said no in a referendum in 1992, and then the court was moved to Luxembourg and came there in the summer of 1996. Interestingly, parts of ESA were also in Geneva in the beginning, so it must have been quite complicated. The EFTA Court has a very simple and straightforward language regime. The working language is English, so pleadings are submitted in English, judgments are drafted in English, and more or less everything takes place in English. That's nice and simple. The court doesn't have any translators or interpreters working. All that is farmed out. There is the only deviation from this principle of English as a working language is in the advisory opinion. The main parties, or the parties in the case pending for the national court, they may both submit written and oral observation in the language of the court. So if it's a reference from the Norwegian Supreme Court, the parties to that case, they can submit in Norwegian, both in writing and orally, but anyone else is obliged to speak English. I think this is a good rule. It makes sense and is very efficient. And in fact, it's quite rare that we get something that is not in English. We tried to be reasonably swift. I have here 8 to 12 months. And as you will see, that depends on whether this is a direct action or an advisory opinion. And of course, in particular in the advisory opinion, where the national court has stayed the proceedings, it matters to be swift. So we try at all costs not to exceed 1 year, and that thankfully rarely happens. And sometimes if things go really smoothly, it can be done in around 6 months, but that doesn't always work. Then we come to the type of cases. And this slide looks a little bit daunting with all these numbers and abbreviation, but it isn't that complicated. In essence, these are 2 types of cases. Cases ESA brings in the field of internal market and challenges against ESA's decisions in the field of state aid. There are some minor nuances, but that's essentially it. The EFTA Court, if someone spots their Article 32 of the SCA, there is the possibility that another EFTA state sues in front of the court one of the other 2, or both other 2. I suppose that's theoretically possible. This has never happened, and even if the EEA agreement lives to be 50, I'm willing to take a bet that it will never happen. This hadn't happened for decades at the Court of Justice, but recently there have been a few cases, even a very high-profile one where the Czech Republic brought Poland before the Court of Justice because Poland had failed to close a mine which broke, I think, all conceivable environmental norms. And that led to, I think, first that the Avenue John F. Kennedy in Luxembourg was closed due to protest because of the actions or inactions of the Court of Justice, which, at the EFTA Court, we are spared such events. So the infringement actions, I'll just, what I have here is Article 31, that is the SCA, Association Court Agreement, that is the legal basis of the infringement action, which you saw a slide, starting with a letter of formal notice, or the formal procedure starts with a letter of formal notice, then the reasoned opinion, and then finally the referral to the court. This, even if this is in an instrument only by the EFTA states, this is modeled on EU law and the provision of the treaty, and it's by and large identical. There is an important difference that, unlike EU law, where states can be subject to penalty payments, both for failure to implement directives and compliance with the judgments of the Court of Justice, this possibility does not exist as a matter of EEA law. If you look at the canon of the court's case law, there's a very high number of cases brought under this article, but mostly this is linked to a failure to implement regulations and directives. I think there was a period in particular when Iceland was doing very badly in implementing regulations that led to a high number of these cases. And if I read the numbers on the slides shown to you previously correctly, 212 infringement cases, I would guess about 60% of them are Iceland not implementing regulations, and similar tendencies can at a certain point in time be seen in the court statistics. So this is when ESA is, so the plaintiff brings the case to the court. Then we have the second limb of the direct action, the Article 36. Then ESA acts as a defendant. These are cases, well, in practice, they're almost all on state aid, 2 on competition, and a handful on access to documents. So in practical terms, we're always looking at state aid. And there are 2 cases like that pending at the moment, and they are typically brought by private applicants who then think ESA should have done something differently and want to annul ESA's decision. These cases are relatively complicated, and they raise issues both of a procedural and substantive nature. And if you're familiar with EU law, there's been an enormous discussion on the standing of private applicants and all that, which sort of, thankfully, EEA law doesn't cover all of those complications. Then we come to the second type of cases, the so-called advisory opinion. And again, this follows quite closely on the EU model, where you have preliminary references to the Court of Justice. There is a difference that these are advisory opinions, so they're not formally binding. And I'll get back to that. And that was one of the main issues in the EEA negotiations, that the EFTA states did not want to transfer judicial power. So that led to this compromise of advisory opinion. So a few things here: who can request, that's court or tribunal in an EFTA state. And the important thing here to note is that this is a broader concept than a court under national law. So if you look at, for example, Norwegian and Icelandic administrative law, many bodies which are administrative tribunals and sort of part of the administration as a matter of national law, they are a court within the meaning of EEA law and can request an advisory opinion. It is for the court sitting with the case to decide on the opportune moment to refer, although ideally, of course, it's better to refer once the facts have been established to a certain degree, so you don't have a lot of uncertainty around the facts, which might impact the answer. Although, of course, if that's referred, then that's the decision of the national court, but that's suboptimal. And then I have here within speech mark that it's always followed, and that's something I want to revert to. So, yeah, I have here the question. My bullet point number 3 is, does this matter in practice? My preferred answer is no, it doesn't matter at all, and that's almost true. All the national courts in all 3 states, or should I say, national Supreme Courts in all 3 states, have recognized the special nature of the advisory opinion. This was, for example, dealt with in plenum by the Norwegian Supreme Court already in 2000, in the so-called Finanger case, which set out sort of the principal status of these advisory opinions in the Norwegian legal order, which grants them not a binding effect, but something quite close to. And there have been, in almost 30 years, some problematic instances, but nothing too serious. I have mentioned here two examples, and one is a case, the one from 2011, STX, was on the interpretation of the Posting of Workers Directive, which of course is quite a sensitive topic. There, the Norwegian Supreme Court disagreed with the EFTA Court's interpretation of that directive in a judgment from 2013. This led to that the Norwegian Employers Association complained to ESA, which in 2016 launched infringement proceedings, which after some time and reflection resulted in the board, the responsible administrative body in Norway, taking a new decision, which more or less reflected the EFTA Court's understanding of this directive. ESA closed the case, so no problem. But this was, of course, quite a long-standing saga, but I think it is really it's a very exceptional case. Another variation on this theme is found in the Fosen-Linjen saga. I think it's fair to say this was on the many aspects of procurement law were under considerations in this case, but here in particular the issue was on the threshold of liability, whether it was the same liability standard as generally in the field of state liability in the EEA or something else, or something the threshold was lower. The EFTA Court in its case, Fosen-Linjen 1, said it's lower. The Court of Appeal in Norway said, we're not convinced, we think this is an incorrect interpretation of the relevant case law, and we read the Finanger judgment we read this as the conditions the Supreme Court has set in Finanger for deviating from the EFTA Court being fulfilled, so they deviated. This was then brought to the Norwegian Supreme Court, who asked the EFTA Court again, and then the EFTA Court clarified its answer, which then the Supreme Court followed. So this, had a happy ending, I think is fair to say. And here it's worthwhile that the Norwegian Supreme Court wasn't breaking any new ground by this second reference. This is a known tactic by Supreme Courts in the EU when they are dealing with something where, to put it diplomatically, they are not necessarily convinced that the Court of Justice did the right thing. They do ask again. This is cooperation of sorts, but at least it ended well. I think there is no duty to refer in a similar manner as in the for national Supreme Court. I think the EFTA Court has said that is true, but of course they should bear in mind their duty of loyalty as a matter of EEA law, and I think that's relatively uncontroversial. If you remember my first slide, I quoted Sveinbjörnsdóttir, and that establishes state liability. I've taken this quote because it captures a few things. It says that the EEA agreement is an international treaty sui generis, and so we have here quite a few important points. It's not a customs union, but more than a free trade area. It's not public international law, but it's not EU law. But what is it? It's something special. So I think this and the next judgment, Osbelt, which is a judgment that came 5 years later from the Court of Justice, they are really, if you're not a lawyer and you read two judgments about the EEA, you should read these two, because this really captures the nature of this, and that it actually what the EEA agreement set out to do, to extend the internal market to the EFTA states. It succeeded. And I think I've highlighted here how the Court of Justice phrased this, that the internal market established within the European Union is extended to the EFTA states. That was what it set out to be, and maybe wasn't always so clear that it would succeed, but it certainly has. Then I put here a much more recent case, the so-called NAV1. At least those who are Norwegians are in the room or was the stream, and I see from the laughter they know these NAV cases, which was, misapplication of EEA law in the field of social security. I use the word misapplication because I think it's polite, but you could use a stronger term if you prefer. Essentially, this was all about export of benefits in pending short stays in another EEA states. And the Norwegian administration had said, if you move, okay, you don't necessarily lose the benefit, but if you just stay some weeks somewhere else, you lose the benefit. This, thousands of cases and several criminal convictions, even a few by the Supreme Court, and of course many claims for repayment. This came to light now 2.5 years ago in the autumn of 2019, and that led to a reopening of many cases and a complete re-examination. And the Supreme Court referred 16 questions to the EFTA Court, and that I think is the record for an advisory opinion. And I could easily discuss this at length, but I just picked the main points of this so-called first NAV is that this work assessment allowance, which is called arbeidsavklaringspenger in Norwegian, is a sickness benefit, and from that qualification it means that it is in principle freely exportable, and under the new Social Security Regulation 883/2004, which came into force in the EEA in mid-2012, the Norwegian practice or rules were in breach of the export rule on these benefits, and previously it was a unjustified restriction on the freedom to provide services, as there was not an export provision explicitly in the regulation. I see I put slightly too much text there because I wanted just to highlight the complexity of social security law and how difficult it is perhaps sometimes to navigate, because this is the conclusion for sickness benefit. But when it comes to unemployment benefits, where the Social Security Regulation is not a coordination instrument, but a harmonizing instrument, there these restrictions were found by the court to be in line with the Social Security Regulation, because the exportability of unemployment benefits is very tightly prescribed by the Social Security Regulation. Then, again, I come to my favorite word in this context, homogeneity. And the EEA agreement, or both the EEA agreement and the Surveillance and Court agreement, place a very clear obligation on the court how to interpret EEA law, and that is to be done in conformity with the case law of the Court of Justice. And the EFTA Court has established what I call here a reputable presumption, that it is interpreted in line with or in the same manner as corresponding provisions in EU law. Again, means the same. That's the key. The court has accepted that, given that the EEA agreement is a different beast, there are differences in scope and purposes. In very, very specific circumstances, it has been interpreted differently, but the one who maintains that argument needs to convince the court of that, and that is quite a high threshold. I have here an early case from the court where this is spelled out very clearly, and this has been repeated many times. This was about residence requirements for board members in Liechtenstein. It was quite similar to a case, an Austrian case, which had been dealt with by the Court of Justice. Liechtenstein for the purpose of the point I want to make here, Liechtenstein argued in front of the court that the concept public policy, which is one of the exception grounds, meant something different because we were in the context of the EEA, not in the context of the EC treaty. And the court here said, no way, it means the same, it is the same. And so in sort of more formal language, without any specific circumstances being present, homogeneity should prevail. This has many, many times been endorsed by the Court of Justice, and I just picked here at random a tax case called Keller Holding, and it says identical in substance, interpreted uniformly. So this, but I think cannot be sufficiently stressed that this is really the key thing. And this was maybe not obvious from the outset, that there is, to a very, very limited extent, any specific EEA interpretation. Of course it exists, I will show you that. Then there's a complicated situation for the EFTA Court, how to deal with if there is a divergence between the case law of the EFTA Court and the Court of Justice. And this came to head in the so-called L'Oréal case, where the EFTA Court had, in the late 90s, said that under the Trademark Directive, there is a so-called international exhaustion of trademarks, as opposed to an EEA-wide exhaustion of trademarks. So in 1998, the EFTA Court opted for this solution. The ECJ was faced with the same question and said, no, there is an EEA-wide exhaustion. So a few years later, a rather perplexed judge in the Oslo Tingret asked the EFTA Court, how do I resolve this? Basically, you say A and the Court of Justice says B, and the EFTA Court essentially said, if the Court of Justice has said B, we will follow and say B unless there are something EEA-specific circumstances which would justify the divergence. So effectively, the EFTA Court said homogeneity is the leitmotif, and the fact that we have said something first doesn't change anything. The assessment is always, is there something in the EEA itself which justifies that we maintain a different interpretation. And I have here that indeed the EFTA Court has also dealt with sort of the other side of the coin, as it was faced with in L'Oréal, and in the Campbell case from 2019, the EFTA Court was faced with the question, should it align itself with the case law of the Court of Justice when it comes to interpretation of the Citizenship Directive, or more precisely whether an article of the Citizenship Directive gave EEA citizens rights both vis-à-vis their home state, so their country of origin, and their host state. The Court of Justice had made it very clear that this provision did, as a matter of EU law, not grant any rights vis-à-vis the home state. The EFTA Court disagreed and said that its previous case law is based on the legal context of the EEA agreement, and said that that's different, and then essentially that even if the Court of Justice had held to its previous interpretation, that was of no importance in this particular instance because it deliberately departed from the Court of Justice. To wrap up, I want to just mention that the EFTA Court is frequently cited by the EU courts, then I mean both the Court of Justice and the General Court, but in particular the Advocate General. They, of course, they write, their style is different. It's more, explores the issues in more detail, so it allows for, exploring other avenues. And the Advocate General Trestenjak, in an opinion from now almost 10 years old, called this unique judicial dialogue. And this, I think that case also serves to illustrate this rather well. The EFTA Court had, prior to any case law on that existing by the Court of Justice, recognized that damages under the terms of the motor vehicle directives also covered or also obliged the state to provide for non-pecuniary damages. So Madame Nguyen, she had lost her husband and child in a traffic accident, and the EFTA Court said that it was Norwegian law should, to be correctly applied under the terms of this directive, also provide for the possibility of receiving non-pecuniary damages. And what's the time, Thorfinnur? Okay, then I'll just leave this slide with you. So thank you, and then we can take questions.
Yeah, let's take a few questions properly together. Only my question is
this one.
So, yeah, first couple of questions to you, Professor. There is, when there's a case against an EFTA, how often is the ruling in line with ESA's?
We try to win the cases. So if we don't think we have a good case, I think we'll try to, we will not go that far. So I don't have any statistics to share at the moment, but it's an interesting question and I will look into it.
Yeah, you don't have a scoreboard like you have?
No. For the internal market, we have a scoreboard. So the graphs I was showing before, you'll find them on our website. And it's a biannual exercise like the European Commission does as well. All of that is on the website.
Yeah, yes.
If I may add, I think if we discount the cases only on non-transposition, I think ESA would have won sort of 3/4 of its cases in front of the court. Roughly speaking, I haven't looked it up recently, but I think that's a reasonably accurate estimate.
All right, that's a good one. Another one to ESA, why does ESA have so many infringement cases with Iceland relative to the other states?
I think you answered that in your presentation.
Yeah, I think I actually alluded to it in my presentation. I think it's the failure to incorporate regulations. Yeah,
that explains
that's
a big part
guess,
of the infringement cases that I can say. Yeah.
Okay, I'll simple as that. Actually, this one is very technical. I don't know if you want to take that one. It's about the treaty and CSA. But it's, would you read it out?
Yeah, so it's a question for the court. Could I ask about the difference between TFEU, the Treaty on the Function of the EU, Article 267, and the Surveillance and Court Agreement 34? The binding nature of ruling opinion, validity of union acts. And is the EFTA Court ever cooperating with the Court of Justice or giving an opinion on matters also dealt with by the Court of Justice? I think I'm not going to say anything about that, as you might, but on the, I thought I had tried to explain the difference in a nutshell between 34 of the SCA and 267 of the TFU. Yes, there's a difference in that the advisory opinions are not formally binding, although I think it's pretty close. And also, I mentioned that only in passing at the beginning, and I deliberately didn't go into the details on that. The EFTA Court does not have jurisdiction to rule on the validity of EEA acts. So, for example, like a case like the Court of Justice was dealing with in full court yesterday on the legality of the conditionality mechanism, those cases simply do not exist within the EFTA pillar.
And that makes perfect sense because of the difference of the EFTA pillar compared to the EU pillar. What is incorporated into the EEA agreement, even though it is secondary legislation, becomes at the same level as the agreement itself. So there is no court to rule in the EFTA pillar on invalidating things that the states have decided should be the law in the EFTA pillar.
Another question about not implementing this question about whether or in which policy areas are the EEA states worse, like to implement timely and correctly.
I think in the areas where there is a big corpus of acts incorporated at the same time, that creates some stress and tension with the national administrations that need to take in and transpose a lot of legislation. So we see very regularly that when it is big waves of legislation, we've seen it in financial services, to take one example, it takes some time to come in line, but it's a question of time, not of political will, which is very reassuring.
Yeah, no, I think that's, and then of course the fields where there's a lot of EEA law, transport, food safety, and the usual suspects.
Exactly. Any questions from the audience before we wrap up this session? Yes. Nice. 2 questions.
Hello, my name is Elena. I'm from Norway House. For your presentation. Very interesting. I have a question. You talked about the infringements. During the infringements with another state, do you experience when you require that another state to follow the EEA law? Do you experience that the member states in your requirements to be binding, or you often go to the EFTA Court?
That's a very good question. I think it links up very well also with what you said, Ólafur, about whether it matters that the advisory opinions are non-binding. I think what we see is a clear political will to be the good students and to do things properly. But there are difficulties that are internal because it's too many laws at the same time, or because things have been happening in a certain way for decades in that state, and changing that to a new model of a new legislation coming in creates difficulties. And there can also be differences in the interpretation. Sometimes we can read the same provision in different ways because it was not very clear from the beginning. But I have never experienced or never heard that the argument was about, well, we don't have to do it. There is a clear basic understanding that to have a well-functioning EEA agreement, every intervener in the process, the states, us, need to do as much as we can to do our part. And that's why we engage in the dialogue. And it happens in good faith, I can assure you.
Thank you. Maybe one more question.
Thank you so much. My name is Ingvild. I'm from the University of Bergen. I also have a question for ESA regarding infringement cases. I was wondering about at which stage do you usually see the cases being solved leading up to courts? If it's in the earlier stages, or if you see that most cases go as far as to the courts? Thank you.
Now, statistically, very few cases reach the court stage because they will have been resolved before. At the stage of a letter of formal notice, so the formal part of the procedure, but it's still before the court, at that stage, things get serious. And if there was not so much active engagement from the states beforehand, then it becomes really, there's much more engagement at that stage sometimes. And we know that, and we use that with sparsity. Sometimes the departments really want to have that change, but they don't get the financing for it from the budget. So us issuing a letter of formal notice, making clear that there is an obligation to do something about that, actually sometimes helps internally the departments that actually need to implement it to get the funding they need to do that. So sometimes it is at that stage, but even at the investigation stage, when it's about individual cases, a lot of the individual complaints are resolved before we reach any stage of letter of formal notice. So I would say for systemic cases, a lot happens also before the formal stage, but when it's about very big issues, it's usually at the stage of the LFN and the reasoned opinion that they get systemically resolved.
Thank you. Anything more from you?
No.
Okay, we are a few minutes to be past the time limit, so if any of you need to ask a question, just do it. But I think we covered most of the questions. And if any in the chat didn't get a reply, just send me a question by email or something. We will always reply to you. So thank you very much.
Thank you very much.
Thank you.